If you'd like to see how a court handles a FCRA, Fair Credit Reporting Act case when there's duplicate reporting, in other words, the creditor is reporting a balance and the debt collector is reporting a balance on the same debt, then I think you'll enjoy this video. It also gives a great explanation for when a provider of information or a furnisher of information to the credit bureau, like, for example, a credit union, does a lousy investigation. And when that can go to the jury to decide whether that was negligent or willful. And if it's willful, that can be punitive damages. So let's take a look at this case. My name is John Watts. I'm a consumer protection lawyer, and a large part of my practice is suing furnishers of information and credit bureaus, all under the FCRA, the Fair Credit Reporting Act. So in this lawsuit, it really has to do with a duplicate account. So he gets a loan, the plaintiff does, from Clearwater, which Clearwater is a federal credit union. And then Clearwater sends that account to this debt collection agency doing business as Northwest Collectors. And so the consumer gets a copy of his credit report and says, wait a minute, this debt is being listed twice. So Clearwater, the credit union, reports that there's a balance of $10,000. So that would be not, well, there was a balance, but now it's zero. But no, they're listing $10,000. And then the second listing, Northwest, which is the debt collector, reported a collection account, and now that's over $12,000. And so the consumer kind of naturally sends dispute letters to the three major credit bureaus, that's TransUnion, Equifax, and Experian, and says, hey, what's the deal? You've got this account twice, and I want you to notice the questions. Questions are very, very powerful when you're doing a dispute letter to say, like this consumer did here, who do I owe money to? I'm confused. Why are both accounts reporting on my credit report? Are there interest or collection fees I'm not aware of? Trying to repair my credits has me puzzled. In other words, it looks like, $22,000 is owed instead of about $11,000. And then he says, hey, he had some problems obtaining credit and had some emotional distress. So we've got two different corporate witnesses from Clearwater. So this lawsuit, at least this opinion, is not related to the collection account. And so these two witnesses talk about eOscar. So let's take a little break. And we have an entire video on eOscar. But so you send a letter to the credit bureau, the consumer reporting agency. They use eOscar. Just think of it like a communication pipeline to the furnisher of information. Then the furnisher of the information sends their results of investigation back to the credit bureau or the CRA. And then ultimately the credit bureau goes back to the consumer and says, here's what we've all decided to do here. So eOscar allows this witness to see disputes that have been sent from the credit bureaus. And then these disputes are called ACDVs, so Automated Consumer Dispute Verification. And the dispute resulted in an ACDV. So just think of the ACDV travels through this eOscar up here. It said duplicate. So it's kind of telling you exactly what's wrong. And so this first witness said, well, we verified his personal information, the balance, account status, and said, hey, it's accurate. And that's standard procedure. Okay. So really what they're doing is making sure what the bureaus are reporting matches what's contained in the internal system. Now there's another witness. This is the first witness's supervisor. And so this witness says, you know what? We at the credit union understood that the consumer is saying there are inaccuracies because there's duplicate reporting. But we don't care. We focus the investigation on simply verifying the information matched the information in the system. So they go, we know you talked about duplicate. You asked questions about that. We don't care. And so this witness says, as far as she knows, Clearwater did not conduct any specific legal analysis of whether the reporting of the debt was proper, aside from reviewing the Fair Credit Reporting Act. So now here's the discussion. So we have a summary judgment motion here. And so if the moving party, normally the defendant, can demonstrate there's no genuine issue of material fact. A material fact is a fact that can make a difference in whether you win or lose. Then we look at whether the non-party has failed to make a sufficient showing on an essential element. All right, if the evidence is merely colorable or not sufficiently probative or important, summary judgment should be granted. If there's any doubt, then resolve that against the moving party. So, all right, what does all that mean? That means here are the furnishers moving for summary judgment saying, Judge, don't let it go to trial. And they've got to show there's no issue of material or important fact that's in dispute. So you can think of like a car wreck case. You and I are in a car wreck lawsuit, and we meet in the intersection. I say I had the green light. You say you had the green light. Well, we've got a dispute of material fact there. Very important. Who had the green light? So that needs to go to the jury. And if there's doubt, then the one that is not the moving party, in other words, the consumer, then you're supposed to rule that or sort of infer or construe doubt in favor of the consumer and against the furnisher who filed for summary judgment. So let's see how this plays out. So we have Congress enacted the FCRA protect consumers by ensuring fair and accurate credit reporting. And so that's in that first part of the FCRA. And we've started a video series on the sort of section by section here. All right, so entities that report consumer information to the credit reporting agencies are called furnishers. So that's who we're talking about here. So 1681 S2A prohibits furnishers from reporting information that is incomplete or inaccurate. Now, you can't sue for this section 1681 S2A, you cannot sue for. But section 1681 S2B, so B instead of A, provides a cause of action. So a cause of action just means you can file a lawsuit where a furnisher fails to properly investigate a dispute over whether information is provided is incomplete or inaccurate. Now, the dispute has to come through the credit bureau. So remember, if we go back up here to our very fancy drawing here, you notify the credit bureau. They then notify, whether it's through EOSC, which is how they do it, or they could send a telegram or, a carrier pigeon, however they do it. If they notify the furnisher, now the furnisher has obligation under that section 1681 S2B. So let's go back to our text here. So now this court's going to give us what you must prove under S2B. So number one, dispute an inaccuracy by notifying a credit bureau. Number two, the credit bureau contacted the furnisher. Number three, furnisher did a lousy investigation. I've got this in my very fancy handwriting over here. Notify the CRA. CRA notifies the furnisher. Furnisher does a lousy investigation. So inaccurate information can be, it's just factually incorrect, or it could be incomplete, and information that creates a misleading impression. So the judge says, and this judge is in the Seventh Circuit, says, well, Seventh Circuit hasn't decided whether double reporting is a violation, but district court, so that's not the appellate court, that's the trial court. District courts have found that this is an issue of fact. In other words, a judge can't sit there and go, well, I've decided that this can't possibly be wrong or misleading. No, we need to let a jury look at it. So here are some examples. All right, so let's look at this judge said, I find those decisions be well-reasoned and persuasive. An issue of fact, remember that's what means we can't have summary judgment. Issue of fact exists whether the double reporting left a misleading impression that he had two separate debts totaling $22,000 instead of $10,000. I'd also say that in my view, it's not just that it's misleading, it's just inaccurate. He does not owe two companies these debts. Okay, there's not $22,000 worth. Either he owes the debt collector or he owes the credit union. He cannot owe both. Okay, so I would just say, if I was writing this opinion, I would say yes, this is a misleading impression, but it's also just inaccurate. All right, so now we have to look and say whether the investigation is reasonable is a factual question normally reserved for trial. So this is typically if you can show that there was an inaccuracy or a misleading piece of information, then normally the rest of it goes to the jury, because whether the investigation was reasonable or not is something that a jury decides. So in a car wreck, you say, well, the defendant was driving too fast. Well, normally that's going to be for the jury to decide. They said, but summary judgment is proper if the reasonableness of the defendant's procedures is beyond question. So here, Clearwater responded to the Consumer Dispute Forum, that's the ACDV, by comparing the information being reported with the information in its internal records. And then it said, hey, it's accurate. Even though the ACDV, remember that's the thing that travels along eOscar, contained the message duplicate, and they admitted he had written about the duplicate reporting, and they did not address this issue or request an alteration. So a jury could reasonably conclude Clearwater's investigation was inadequate, and it may qualify as a willful violation, giving rise to statutory or punitive damages, and that the jury has to decide. Here's the test under the Safeco case. You have to look and say, was the risk of violating the law substantially greater than the risk of reading the FCRA that was merely careless? Well, here, it's very obvious what the law requires. You must do a proper investigation. And for Clearwater, the furnisher, the credit union, to just say, we're not even going to pay attention to that whole duplicate thing. That means it goes to the jury on whether or not this was willful, which could mean statutory damages, $1,000, but more importantly, punitive damages to punish and deter this credit union and other companies, other furnishers from doing the same type of lousy investigation. And we have here, he's got anxiety disorder. And Clearwater says, well, your credit report wasn't disclosed to third parties, but he said a loan officer reviewed the credit report and said, I'm not going to give you an opportunity for a mortgage. Now, we'll see a case in another video where a judge may have ruled slightly differently about a mortgage broker refusing to do something. So you have to know what your law is in your area with your judges as to how much proof and the type of proof that you need to provide. Okay, but this gives you an idea for this particular court what was sufficient. So they say the defendant Clearwater's motion for summary judgment is denied. So what's the take-home message? Well, the take-home message is this reminds us that to be successful against a furnisher, that's under that section 1681 S2B, we have to notify the credit bureau. It's not enough to notify the furnisher directly. That's fine to do, but you have to notify the credit bureau, who then notifies the furnisher. Then the furnisher has to do a lousy investigation. So you notify the bureau notifies the furnisher does a lousy investigation. And when they just ignore your dispute, the language of your dispute, and sort of investigate something else, well, that can be a lousy investigation. So here's sort of an example we use sometimes. Imagine that you take your car to the dealership because your transmission is like completely shot. And you say, I need you guys to repair or replace the transmission. They go, great. They call you back, say, your car's ready. You go there, you say, so what'd you do to the transmission? They say, nothing. But we replaced all 4 tires. You're like, well, I didn't ask you to replace the tires. I asked you to fix the transmission. And so that's what these furnishers are doing. And same thing with the credit bureaus. When you're very specific in your dispute and they just ignore that and they say, but we investigated something else. Well, I didn't ask you to investigate something. I asked you to investigate the thing that I wrote in my letter or my online dispute or my telephone dispute or however you disputed it. So I hope that you found this helpful. We'll continue to do these case decisions because I think that it's great to, for me just to talk about stuff, and I'm happy to do that, live questions and things of that nature. It's great to go through the statute. Okay, very, very important to understand that. It's also nice to see what do real judges think about this. Now, I don't always agree with the judges. The judges don't always agree with themselves. We'll see that we're going to look at a case here in a couple days. I'm not sure exactly when it will be released, but it's a judge in South Florida who's saying, well, my fellow judges, some say this, some say that, and here's who I decide that I think has the better opinion on. So just because a judge writes an opinion does not mean that we agree with it, does not mean an appellate court, the higher court, will agree with it, but it is important for you to see, well, what do judges believe about this? And it also helps just kind of make this all very practical to see how this shakes out in a real case. All right, guys, thanks for watching this, and I will catch you in the next video, and you guys have a fantastic day. Bye-bye.